Hello students and welcome to the lecture. So students, as we know that we are covering the salient features of the constitution, and basically you could say that these are the topics we have scheduled for the discussion under this series. Like starting with the introduction, thereafter the salient features of the constitution, criticism of the constitution, schedules of the constitution at a glance, and the sources of the constitution at a glance. Alright. So far we have completed the introduction. Alright. Since last few lectures, basically we have been discussing upon the salient features of the constitution. The topics which we are left with is the criticism of the constitution, schedules of the constitution at a glance, and the sources of the constitution at a glance. So we will continue from where we had left in the previous lecture. All right. So basically we have covered till the fundamental rights salient feature of the constitution. Now what we are going to start with the directive principles of state policy. What does it mean? It means that according to the B.R. Ambedkar, who was the drafter of Indian Constitution, he said that the directive principles of the state policy is novel feature of the Indian Constitution. Okay? So remember, if the question asks you in the examination, like who declared the directive principle of state policy as a novel feature of the Indian Constitution, the answer should be Dr. Bhimrao Ambedkar. Maybe the question could be different. Like it will happen that Dr. Bhimrao Ambedkar declared following which of the following feature as a novel feature of the Indian Constitution. The options are the active principle of state policy, the preamble of Constitution, the fundamental rights, or the integrated and the independent judiciary. So what should be the answer? The answer should be this one. Okay, so that's how the questions could be formulated. They are enumerated in part 4th of the Constitution. Remember, the fundamental rights are in part 3 and the directive principle of state policy are in part 4. All right. They can be classified into 3 broad categories. Okay, like the socialistic principles, Gandhian principles, liberal and intellectual principles. All right, remember this thing. Like we have divided them into the 3 categories: socialistic, Gandhian, and the liberal intellectual. Remember that where the fundamental rights are basically enumerated to ensure the political democracy. Okay, the directive principles of the state policy is basically enumerated to promoting the ideals of social and the economic democracy. So remember that is the difference. They seek to establish a welfare state in India. All right, so that's why these are idealistic, idealistic in nature. However, unlike the fundamental rights, the directives are non-justicable in nature. That is, they are not enforceable by a court for their violation. Like as we had seen in the, you can see the previous, like Article 32 and Article 226. These two articles having the capacity, like if someone feels that his or her fundamental rights have been deprived of, then he could reach the Supreme Court and the High Court respectively. But in case if someone thinks that the directive principle of state policy are not fulfilled, then the person could not reach any court. Why? Because they are non-justicable in nature. And hence they are not enforceable by courts for their violation. Okay, so the provision of reaching the courts in case of violation is only available in the case of fundamental rights, but not available in case of the directive principles of the state policy. Got it? Yet, the Constitution itself declares that the principles are fundamental in the governance of country and it shall be the duty of state to apply these principles in making laws. Alright? But however, the Constitution is here which declares that these principles are fundamental in the governance of the country. Why? Because they promote the socio-economic democracy. Got it? So that's why this makes the duty of the state to apply these principles in making law. Or you can say these are the ideals and inspirations the state could take into consideration for making laws and regulations for the welfare of country and its people. So remember, these are the ideals and the inspirations the state could take into the consideration for making laws and regulations for the welfare of country and its people. Got it? So remember this thing. All right? Hence, they impose a moral obligation on the state authorities for their application. But remember, moral obligation, not any kind of legal obligations which were available in the case of fundamental rights. But but the real force, or you can say the sanction behind them, is political, that is public opinion. All right, it means that it is depend upon the government, political, that what the public want and how this could be done. Okay, in the Minerva Mill case 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. So again, we got an you can say topic from which the question could be formed. Like what was the case? Like what was the case in which the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principle. So the answer should be Minerva Mill case 1980. Got it? The original constitution did not provide for the fundamental duties of this citizen. Remember this thing. All right. Okay. There is a one thing. Like we have finished the directive principle of state policy. Now we have the fundamental duties. Okay. Like we have the fundamental rights. Okay. Thereafter, what we have the directive principles of state policies. All right. Similarly, we have the fundamental duties. So remember, originally, when the constitution was formed, they both were available and mentioned in the constitution. But this was not available and mentioned in the constitution. Like you could see here also, the original constitution did not provide for the fundamental duties of the citizen. Okay, these were added during the operation of internal emergency in 1975 to 77. Basically, what happened? That these 2 years were the years of emergency, which erupted in India due to the political unrest. Okay, because of this, many things had taken place in India and many changes had been made into the constitution. And as we know, the 42nd Constitutional Amendment Act, which is often regarded as a mini constitution. Why? What was the reason? Because in this, various provisions have been introduced to the country. All right. And basically, fundamental duties were one amongst them. All right. So that 42nd Constitutional Amendment, which is the mini constitution, which was introduced in the 1976, fundamental duties had been included to the constitution for the first time on the recommendations of Swaran Singh Committee. So here we have, you can say, drafted some questions like fundamental duties was not available if these options are given in the examination. And the question is, out of these options, which was not originally available and mentioned in the constitution, what should be the answer? The answer should be fundamental duties. If the question asks, like, during which years the fundamental duties were introduced to the constitution, it was a time period of internal emergency 1975 to the 1770. If the constitution asks, if the question asks, through which constitutional amendment act the fundamental duties were introduced to the constitution, the answer should be 42nd Constitutional Amendment Act of 1976. If the question asks, like, which was the committee which recommended the fundamental duties, the answer must be Solan Singh Committee. All right. So these type of questions could be framed from these lines only. The 82nd or 86th Constitutional Amendment Act of 2002 added one more fundamental duties. So remember, basically, the fundamental duties were introduced by the 42nd Constitutional Amendment Act of 1976 by the recommendations of the Saran Singh Committee. But another fundamental duty was introduced in 86th Constitutional Amendment Act of 2002. All right. The part 4th A. Okay. It means that part 3rd, part 4th, part 4th A. All right. Part 3rd. Fundamental rights. Part 4. Directive principles of state policies. Part 4A is fundamental duties. Got it? So basically the part 4A of the Constitution, which consists of only one article 51A, specifies the 11 fundamental duties. So remember how many duties we have? 11. 11 fundamental duties, like to respect the Constitution, national flag, national anthem, to protect the sovereignty, unity, and the integrity of the country, to promote the spirit of common brotherhood amongst all the people, to preserve the rich heritage of our composite culture, and so on. Fundamental duties means basic duties and responsibilities of every citizen towards the country. And we had seen some of them like the respect the constitution, national flag, and the national anthem, to protect the sovereignty, unity, and the integrity of the country, to promote the spirit of common brotherhood amongst all the people, to preserve the rich heritage of a composite culture, and so on. The fundamental duties serve as a reminder to the citizens that while enjoying their right, it means that while enjoying your provisions, or you can say your privileges, they also have to be quite conscious of duties they owe to their country. It means that not only focus on privileges, but also look after the responsibility to the nation. All right. The fundamental duties serve as a reminder to citizens enjoying their rights and discharge their conscious duties which they owe to their country, the society, and their fellow citizens. All right. However, like the directive principles, the duties are also not justificable in nature. It means that if we talk about all the threes, fundamental rights, directive principle of state policy, okay, and fundamental duties. Out of all of these, only the fundamental rights are enforceable. That is, non enforceable. That is also non enforceable. All right. So you could say if someone is not discharging his fundamental duties, then no legal action could be taken against that person. No legal action could be taken against that person. All right. So remember this thing in your mind. Another salient feature we have the secular state. The Constitution of India stands for the secular state. It means that the government do not owe or incline towards any particular religion. Okay. So secular means the government do not owe or incline towards any particular religion. Okay. So you could say the Constitution of India stands for the secular state. All right. Hence, it does not uphold any particular religion as the official religion of the Indian state. Okay. The following provision of the Constitution reveal the secular character of the Indian state. The first, the term secular was added to the preamble of the Indian Constitution by the 42nd Constitutional Amendment Act of 1976. So remember one thing, that when the Constitution was framed, and you can say when the preamble was framed initially, basically no word like secular was mentioned. All right. So we could say that the word was added later, and the more specific answer is by 42nd Constitutional Amendment Act of 1976. The preamble secures to all citizens of India liberty of belief, faith, and worship. Like it means that anyone who is Indian and who is living in India, he has a liberty to follow any belief, faith, and perform any kind of worship. All right. But there is a restrictions which we will tell, you can say, which we will discuss in the deeper form when we will learn about the fundamental rights. And this restriction is public morality. It means that whatsoever belief, faith, and worship you are doing, that not, you can say, against the public morality. All right. Thereafter, the state shall not deny to any person the equality before the law or equal protection of laws. It is Article 14. It means that any person who belongs to any community, any religion, is not going to be the victim of unequal treatment in case of law or before the law. It means that everyone will get the equal protection of law and anyone is equal before the law. Thereafter, the state shall not discriminate against any citizen on ground of religion. Article 15. Equality of opportunity for all citizens in matter of public employment. Article 16. All persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate to any religion. Article 25. All right. Every religious denomination or any of its sections shall have the right to manage its own religious affairs. Article 26. No person shall be compelled to pay any taxes for the promotion of particular religion. Article 27. No religious instruction shall be provided in any educational institution maintained by the state. Article 28. Any section of citizens shall have the right to conserve its distinct language, script of culture. Article 29. All minorities shall have the right to establish and administer educational institutions of their choice. Article 30. The state shall endeavor to secure for all the citizens a uniform civil code. Article 44. All right. So students, basically these are the articles which belong to the fundamental rights and the you can say directive principle of state policy. We will discuss them in detail form when we will look after their chapter. Till then, just pay attention to them, look at them. All right. So in this lecture, we have completed here. In the next lecture, we will continue from here. Till then, just revise all the facts and figures we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and